So my webinar is on the importance of specialized prosecutors in human trafficking prosecutions. I am an assistant Crown Attorney in Toronto, and I'm a member of the Human Trafficking Prosecution. The Human Trafficking Prosecution team was formed in 2017 as part of a provincial anti-human trafficking strategy. And as part of that strategy, the Ministry of the Attorney General received funding for specialized human trafficking Crown prosecutors. And so our team, which has 6 members right now, is dedicated to prosecuting only human trafficking cases. We provide ongoing training, like the webinar that we're engaged in right now. We provide legal advice, and we have implemented an enhanced prosecution model, which is part of what we're going to talk about today, for frontline crowns and police across the province. So I've included the names of the members of our team, and at the end of the presentation you'll see contact information for members of our team if anybody needs to get in touch with any of the members of our team. Our team layout is, as I indicated, made up of 5 regional representatives. So there's myself for Toronto. There are 2 assistant Crown Attorneys in Peel and 2 assistant Crown Attorneys in the York region. In jurisdictions where we don't have regional representation, there is at least 1 assistant Crown Attorney in each courthouse that has received training from our team that is a designated human trafficking Crown. So they've been trained in the enhanced prosecution model. They're trauma informed. They have received training in terms of how to prosecute these offenses, and that's all been training that we've delivered. The regional representatives, so the members of our team, are available to law enforcement across the province. We are consistently providing pre-charge consultations and advice. We provide ongoing consultation for investigations. We connect law enforcement, assistant Crown Attorneys with organizations in the community that they're working in. We liaise between law enforcement, community organizations, and the Crown's office for all jurisdictions across Ontario. We also liaise with the Victim Witness Assistance Program as well to make sure that we're working collaboratively throughout the process. We prosecute human trafficking offenses, and we provide ongoing education and training to all members of the criminal justice system, as well as stakeholders involved in the criminal justice system. The focus of our team and the way in which we have developed the enhanced prosecution model is to focus on bail, asset forfeiture, and early and consistent Crown assignment to files. One of the things that we have noticed makes a huge difference in prosecuting human trafficking cases specifically is to avoid having files switch Crown hands throughout the prosecution. So what we try to ensure is that there is 1 Crown assigned from the bail stage, and they continue with that file all the way to the completion of the case. We gather information and compile resources, and we'll talk a little bit about what that looks like as we go through the presentation. We try to ensure that there is consistent advice being given across the province, and this is particularly important given what we're going to talk about in terms of some of the provisions and the how relatively recent they've come into effect, and the kind of process of developing the law and the interpretation of the law. And so it's really been important for us to ensure that law enforcement across the province is receiving consistent advice. We also try to ensure consistency in terms of how we are prosecuting these offenses. So from the charge of screening stage all the way to the end of the case, that everybody involved in a human trafficking case has a shared understanding of what the law is, what is required, and when we would, for example, offer a plea bargain to something other than a human trafficking offense. Key to our enhanced prosecution model is working collaboratively with law enforcement, with social service providers, with victim witness. Really, you can't do these prosecutions alone. You need to have a team of people working with you. And so developing and maintaining and working collaboratively with everybody who's involved in the investigation and prosecution of these offenses is really important. And lastly, we are working with police to ensure, given how difficult these cases can be to prosecute, that we are investigating as much corroborating information as we can to try to ensure that we have as strong a case as possible moving forward with a prosecution. We obviously want to support the reliability and credibility of our victims as much as we can. So that's kind of an overview of our Provincial Human Trafficking Prosecution team. The remainder of the presentation is kind of divided into two sections. The first section is what I would like to talk about is the difficulties in prosecuting human trafficking cases and the difficulties that we've encountered as a prosecution team. And the second portion is dedicated to how we, as specialized prosecutors, and in developing the enhanced prosecution model, have addressed some of these difficulties, hopefully in a meaningful way, to ensure prosecutions that are complete and fulsome and are able to be completed. So I'll start out by talking about how difficult these prosecutions can be. And I want to start first by talking just about how unique these cases are in terms of the people that we're dealing with. Our victims on human trafficking cases are extremely vulnerable. By the time they come to the police, they are generally isolated geographically, financially, emotionally. They are living with a person or involved with a person who has provided for their every need, from their basic needs to their more complex emotional and psychological needs. And that can be a very difficult void to fill. It's very difficult to ask somebody to leave that situation in the absence of being able to provide all of the things that their trafficker was providing. And that can mean something as basic as housing, food, water, identification, all the way to the more complex psychosocial needs. And so by the point that the police are asking people to leave a trafficking situation or are intervening in a trafficking situation, we already need to have a plan in place to be able to provide for all of those things that the trafficker was providing to their victim. And that makes these cases particularly difficult because it's very difficult to provide for all of those needs. And that makes the lure of going back to a trafficker very enticing. And as we go through the presentation, one of the things that we're going to talk about is how people don't understand where a situation where if you've been removed from an exploitative situation, why you would go back. And so it's about, part of what we try to do is to educate people about how difficult it is to leave these situations as a result of the situation that a person is in when they're being trafficked. In addition to that, many of our victims are very vulnerable. They may have mental health issues, they may have addictions issues, they may have unstable family situations, they may be tangentially housed. There are a whole bunch of things that make people very vulnerable to being trafficked. And when you are asking them to leave that situation, to go back to a situation where they were vulnerable, it makes it very difficult for people. All of those vulnerabilities also, as we'll talk about, play out in a courtroom, and they obviously contribute to a judge or judge and jury's interpretation of a witness's credibility and reliability, and so that can make prosecuting these cases very difficult. One of the other things that is unique about these cases in particular is the development of the trauma bond between a trafficking victim and a trafficker. So we talked a little bit about this in terms of someone providing for the trafficking victim's every need. And adding to that complexity is that in the context of at least commercial sexual exploitation, which is what we deal with primarily, we also have a model of trafficking that is really premised on deception. And this idea that a trafficker is in love with and going to provide a condo, a great lifestyle, vacations. They're going to be kind of a knight in shining armor, if you will, for the trafficking victim. And the trafficking victim often feels like this is one of the best relationships they've ever been in. They're completely in love with their trafficker. And that can be a very difficult bond to break. Just by way of an example, I prosecuted a case about 7 years ago. The court process started, and my victim had been with her trafficker for about 3 weeks. She met him, she was trafficked by him, and she managed to escape from him all in the span of 3 weeks. And when she met with a worker who has been working with her since she was trafficked in 2019, so 7 years after the case started, about almost 8 years after she was trafficked by this man, she reported to her worker that that 3-week relationship was the most meaningful relationship that she's ever had, that she's been involved with many people since then in terms of romantic relationships, but she's never felt a love the way she felt for him. And that's pretty telling. 9 years later, she, had a great deal of insight in terms of she understood what had happened to her. She understood what happened to her was wrong. She knew she had been trafficked and she knew she had been exploited by this person. And she was able to articulate that. And she said she knows that boyfriends don't treat people that way. But despite that, she still loved him and looked at that as one of the most intense loving relationships she's ever had. And so that can make these cases particularly difficult because there are a whole host of range of feelings that come along with witnesses who may feel guilty about testifying against their trafficker. They may still love them. They may feel guilty about potential consequences for their trafficker. And so that brings a whole host of complexities with it in these cases as well. Another difficulty can be the money that is available to people working in the sex trade. It can be very enticing for some people. And in a situation where they have left a trafficking situation and they are not in a place where they have somebody or something to provide for those needs, or they're in a situation where their needs are being met or they can meet their own needs, the idea of making $1,000 a day is very enticing. And people often return to the sex trade. And that adds a layer of complexity in the criminal justice system because people don't understand, for a whole host of reasons related to the stigma about the sex trade, why people would go back to the sex trade. The other complicating factor can be if a person returns to the sex trade, they may end up being trafficked by another person. That person may have a vested interest in our victim testifying in our cases, and so we may end up with witnesses who become hostile or uncooperative with the prosecution as a result of influence from a new trafficker. Some of the other difficulties in terms of dealing with people who've been trafficked are that they often come to the system with a distrust of police or the criminal justice system, or because there's a misunderstanding about what is legal and what is illegal in relation to the sex trade. There's a real fear of being criminally prosecuted yourself for being involved in the sex trade, or being involved in some activities relating to the sex trade or relating to their time when they've been trafficked. And so people are quite apprehensive and distrustful of the system and coming forward and providing a full and candid account of what happened. Another thing that makes these cases complicated is the consequences of having been exploited and the effects of trauma. And we may understand trauma, but the criminal justice system, I think, is starting to understand trauma and the way that it plays out. And so we're going to talk about this as we go through the presentation, but the manifestations of trauma can make it very, very difficult for people to engage in the criminal justice system and to make it through a lengthy prosecution. There's also, in what I have experienced with some people who've been trafficked, is that there's a real sense of embarrassment. They feel stigma and shame about how could this have happened to them? How could they have let this happen to them? And so what that results in is people obviously not providing a full account of what happened or trying to minimize what happened out of a sense of shame and embarrassment. Lots of times we hear, people talking about, I can't believe this has happened to me. And when you add that into the stigma surrounding the sex trade, it becomes particularly complex. There's also obviously significantly safety concerns. When people have been exploited, they have often been the subject of threats. They may have experienced physical or sexual violence at the hands of their trafficker, and they are deathly afraid of their trafficker and the consequences of having come to the police and given a statement and testifying in court. And those safety concerns are often very, very valid and very, very meaningful and significant, and cause people to not want to participate in the prosecution because the consequences in their mind of participating in the prosecution are more significant than not participating. As a result of all of this, generally what we experience is an underreporting of human trafficking. When there is a reporting, it's often delayed, which means that there may be a loss of potential corroborating evidence. So what I mean by that is if someone had been trafficked out of a hotel, for instance, and they come to the police 6 months after the last time that they had been at that hotel, if there had been, for example, any surveillance video at the hotel, it would have often already been overridden. So we're not able to have that evidence as part of our case. When people do come to the police, they often initially minimize what happened to them or only tell a portion of it. And so we are in a situation where there's incremental disclosure. And while the law has recognized that you can't make adverse inferences about a person's credibility from either delayed disclosure or incremental disclosure, that doesn't mean that it makes it easy to be cross-examined on why a person's story keeps changing. And so it makes the court process and the process of having to answer questions difficult. All of this is kind of leading up to the court case. Once we get to the court case, the criminal justice system can be a very difficult place for survivors of human trafficking. Oftentimes, people have to relive the trauma when they have to recount their experience of what happened to them, both at a preliminary hearing and at a trial. And it's certainly not uncommon for us to see survivors of human trafficking experience setbacks either in the lead up to having to testify or in the immediate aftermath of testifying. We often see people relapsing if they suffer from addictions or returning to the sex trade or returning to their trafficker. As a result of some of the trauma, we often see people forgetting certain parts of their story, or as a result of those feelings of love or fear, omitting things in their evidence or minimizing things in their evidence. Sometimes as a result of fear and ongoing exploitation at the hands of their trafficker, we have people who, for whatever reason, choose not to participate in the prosecution, and they just stop communicating and they don't come to court. And more generally, because of how the law is framed, it can be very difficult for people to, if they choose to participate in human trafficking prosecution, articulate their experience. And by that I mean, it's very difficult to explain objectively how you found yourself in a situation where you felt like you had to provide a labor or service that you wouldn't have provided otherwise because you were scared. It's very rare that you have a situation where someone is in a situation where that we kind of stereotypically think of as human trafficking, and that's kind of like a Law and Order, you know, someone in the back of a truck being brought across an international border, chained, and being forced physically into providing a labor service. The exploitation that we're seeing is generally much more discreet, and it's very difficult for people to articulate all of the different factors that went into how they were exploited. And so, you know, it ends up that a whole story is not often told because it's so difficult to articulate that. All of this to say that human trafficking cases can be very difficult to investigate, and prosecuting them can be very difficult for everyone involved. And they are often very emotional, very difficult cases. And there's always a fine balance that has to be walked between having a victim-centered prosecution and the concern for public safety, because most times these traffickers are very dangerous individuals, and so we as prosecutors have to be able to balance that to ensure, obviously, that there are no miscarriages of justice. So in addition to some of the unique factors related to survivors of human trafficking and their involvement in the criminal justice system, we also have some other difficulties that we encounter. The first is an uncertain legal environment. So the human trafficking provisions are relatively new. In 2005 was the first time that the provisions relating to human trafficking were codified. So that was the first time that it became a criminal offense to traffic in persons. And that was the offenses in 2005 that were created were the offenses relating to adults, so people over the age of 18. In 2010, the trafficking in persons under 18 provisions were added. The meaning of exploitation in the criminal code was only added in 2012. In 2014, there were amendments made to add the mandatory minimum penalties for the trafficking in persons provisions. And in 2015, there was in Ontario a case decided by the Ontario Court of Appeal that has shed some significant light on the provisions and the legal interpretation of them. So all of this to say that these provisions are relatively new. And because of some of the things that we've talked about in terms of the difficulties with underreporting, there haven't to date been a vast number of these prosecutions, which has meant that the provisions haven't received significant judicial interpretation or commentary. That's obviously changing, and in the last few years I would say that there has been a lot more judicial commentary interpretation of the provisions, but that's definitely something that is relatively recent. So with respect to law enforcement, some of the difficulties of an uncertain legal environment are that officers who aren't trained necessarily in human trafficking or in the provisions of human trafficking may not recognize that what they're investigating is in fact a human trafficking offense. Human trafficking often is a crime veiled by other crimes. It may look like anything from a domestic to an extortion to a theft. So, for example, I had a case where a woman walked into a police station to report that someone had stolen her phone. And through some digging, the officers came to understand that the person who she said took her phone was in fact her trafficker. But thankfully, that officer who started to do some digging and ask some questions knew the questions to ask, and was able to encounter the nature of the relationship and the circumstances that led to her phone being stolen. It is a very rare day where a person will walk into a police station and say, I'm a victim of human trafficking. And so the consequences of this may mean that human trafficking offenses may go undetected or under-investigated. Even if officers are aware of human trafficking and the provisions, sometimes we see officers may not have a thorough understanding of what the actual provisions are and what's required to make out the offenses. And so we have situations where they may not take a complete statement because they don't know the questions to ask, or they may feel uncomfortable asking about certain things, or they may take a statement, but it may not be on video or sworn, which can make things very complicated for people who down the road choose not to participate in prosecution. And so all of that may add complexities to a prosecution. Officers as well who haven't received training in human trafficking may not realize the importance of seizing corroborative information. And so by this I would talk about things like asking the survivor of human trafficking for her consent or his consent to download portions of a phone to their phone, the importance of looking for video surveillance from hotels or other places where the person is reporting that they've been trafficked out of seizing documentation. Those are all things that are really important and may be lost if a law enforcement officer isn't aware of the importance of seizing that information. The other thing I would just say about the importance of having law enforcement trained in human trafficking is the importance of developing trust and a relationship and rapport with people and approaching people who have been trafficked from a position of not being judgmental. One of the most important things about investigating and prosecuting human trafficking offenses is developing a relationship with the person who you're asking to tell pretty intimate details and pretty terrible things that have happened to them. And so oftentimes what we're seeing is that officers will develop a relationship with a survivor of human trafficking before that person feels comfortable enough to disclose everything that's happened to them. And knowing how to do that in a way that is compliant with the law and compliant with disclosure obligations and is respectful of boundaries and healthy relationships is really important. And it's a real skill, because if that relationship isn't developed, then what often happens is people don't provide a statement, or if they do and the officers don't keep in touch with them and ensure they're connected to services and supports that they need, then these people disappear. We don't see them again. And that can be really a real challenge on a whole host of levels, because you want to make sure people are safe. You want to make sure people are connected to services if they're choosing to get out of that situation. And you don't want to lose track of people if they're reaching out for help. Obviously, you want to be able to provide whatever supports you can. So those are all really important things that we are working with law enforcement to train them about, to make sure that we're addressing that underreporting problem. The other thing that we work with law enforcement on often is what human trafficking looks like, what's required. And so when we're providing advice, we're talking to them about what the provisions require, what's required in law to be able to make out the offense, and appropriate ways to draft informations and wordings for court documents to make sure that we're in the best position possible to have a meaningful and successful prosecution. From the perspective of prosecutions and a prosecutor, the first time I ever did a human trafficking case was before our human trafficking prosecution team existed. And I remember spending hours and hours and hours trying to just figure out what was required to prove the offense of human trafficking. The provisions are not written in a way that are easily digestible, and they're complex. And so we're often fielding questions from Crowns about the basics. What is required to prove human trafficking? What are the elements of the offense? Do I need to prove exploitation as a part of proving human trafficking? How do I prove that? What questions do I ask? What does exploitation look like? And if you are a prosecutor in a very busy trial office, you may not, unfortunately, have time to be able to look into and to research all of these things and to really sit with and digest what is required to prove human trafficking. If you don't understand what's required legally, then you may end up screening things down that you don't think are human trafficking, when in reality they are. Or you may offer plea bargains that are not reflective of the actual offense that's been alleged. And you may obviously end up with a prosecution that is not a fulsome prosecution if you are not aware of what you have to prove, so you don't ask the right questions and you're not eliciting the right information. And obviously that is concerning from a miscarriage of justice perspective. We want to make sure that when we are prosecuting people, we are prosecuting them in line with what the law requires, and that the charges are appropriate for people who are being prosecuted, and also that they're reflective of the experience of the person who has experienced the crime that's alleged. Lastly, in terms of the judiciary, the first time I ever argued a human trafficking case, we sat through 10 days of evidence, and I was about to make my closing submissions, and the judge said to me, "So, Ms. Langdon, where's the human trafficking here?" And ultimately he convicted. So it was not human trafficking. But when he asked me that question, what I realized is he was expecting that Law and Order moment. He was expecting somebody to come to court to talk about basically having been enslaved. And that wasn't the story that my two victims told, and that wasn't what the law required. And this judge hadn't had experience with a human trafficking case. And so when he was approaching his analysis initially, he was thinking about it from what he thought human trafficking was. And so I realized the importance at that point of taking a step back and starting from the beginning and saying, okay, this is the process that I had to go through to learn these provisions. Let me now explain them to you. And that was an important lesson because it obviously made me realize, just as I was in that position where I had to spend hours learning and understanding the provisions, that the judges that I was arguing cases in front of were maybe similarly situated, and that I need to kind of start from an education perspective and say, let me make your job easier for you by walking you through the things that I've already learned and digested. So that covers the uncertain legal environment. There are also attitudinal barriers that are difficult in terms of these prosecutions. So the law doesn't require us to prove exploitation, which sometimes is perplexing for people. What the law requires us to prove is that on an objective analysis, a reasonable person would feel fear in the circumstances. And that can include coercion, it can include threats, it can include deception, and it can also include psychological safety. So what that means is a person doesn't have to come to court and say, I was physically threatened and experienced physical violence, and that experience of physical threatening and violence made me do this. That's often not what happens. It can be much more nuanced, and it can look something like, he promised me this great lifestyle, and he was the only person in my life who gave me meaning. And the idea of him leaving me and leaving me homeless and without money and geographically isolated in a place that I'm not familiar with was terrifying to me. And as a result of that, I felt like I had no choice but to provide the labor or service that he's demanding of me. And it's very difficult for people to understand that because of this misunderstanding of what human trafficking is or what it should look like. Some of the other attitudinal issues that we sometimes encounter is oftentimes we have people in the context of commercial sexual exploitation that have started out working independently as a sex trade worker, free from influence or exploitation. They get into a relationship with their trafficker and it becomes a relationship of exploitation. And so oftentimes where that line gets blurred is very difficult for people to understand, and difficult for people to understand how exploitation can happen if you were providing that labor or service prior to being exploited. And so that's where knowing the questions to ask and knowing what's required in law becomes really important, because that's when you have to really paint the picture for your trier of fact to show the difference between what working independently looks like and what working under exploitation looks like. We've talked a little bit about this, but if you've escaped exploitation, why would you go back to the sex trade? Or if there was no physical violence or confinement, why didn't you just leave? And how can you still love or care for the person who exploited you? So a real misunderstanding of that trauma bond. And if you do still love them, was it really exploitation? Or were you choosing to provide this service because you wanted this relationship? And with the attitudinal barriers also comes a distorted view of a survivor's credibility or reliability. So all of the things that make a person vulnerable to experiencing exploitation also play into, in a court, things that can be used to assess credibility and reliability. On top of that, so things like mental health issues, addiction issues, if you are vulnerable, that can be used against you. But on top of that are the effects of trauma and how that plays out in court, and how the effects of trauma may also play into a survivor's credibility or reliability assessment. So if you have experienced trauma and you have, as a result, lapses in your memory, or you have fragmented memories, you may be seen to be an unreliable witness. Or if you, as a result of the trauma bond that you have formed with your trafficker, are minimizing what happened to you, that may be used against you in terms of your credibility assessment. So all of these things, obviously, again, make prosecuting these cases very difficult. Even from outside of the court system, but just from a prosecution perspective, misunderstanding trauma and what it looks like can be a really difficult challenge or barrier. So just by way of an example, I was involved in a case where I met with a woman who was a survivor of trafficking, and I met with her in a place with her support workers where she felt safe. And the first time I met with her, I walked into the room and she was literally curled up in the fetal position, and she had her hood down over her eyes, kind of covering to the middle of her nose with the strings tied tight. And she would not remove her hood. She would not talk to me. And she had requested this meeting. So it wasn't like she was reluctant. I knew she wanted to meet with me and to at least have this initial encounter. And I think in an absence of understanding what trauma could look like or what it may look like, a person may have walked into that situation and thought that they were dealing with a hostile witness and would have treated this person very differently than how I chose to treat her, which was I just kind of sat back and started talking about, I don't know, the color of the room and the fuzzy pillows. And I knew she had a good relationship with the officer who was there. We kind of poked fun at him a little bit. And by the end of the meeting, she hadn't taken off her hood and she was sitting up at least. And we then talked about the idea of meeting again. And she indicated that she was agreeable to that. And over the next 7 or 8 meetings, the hood kind of eventually came down and she started to engage more. And she, by the time that we got to court, was fully engaged in the process. And at a point I said to her, there's a possibility that this could resolve. How do you feel about that? And she said to me, I don't want it to resolve. I want to go to court to tell my story. And that was really an important lesson for me, because I think we have to take into consideration and to think about how we perceive people through this process, especially knowing what they've gone through. And so understanding what trauma looks like and taking steps to meaningfully address it, to make sure that people that we're working with are engaged in the process in a meaningful way for them. And so for her, it was meaningful for her to eventually go to court. And it was quite meaningful that we kept having these meetings and these conversations, and everybody just let her sit with her hood on and let her sit however she wanted. And we didn't treat her like she was hostile or reluctant. We just did whatever we could to make her feel comfortable and to develop that relationship of trust. And for her, it worked. Sometimes it doesn't, but all we can do is try. Some of the other things that are very difficult in terms of prosecuting these offenses are time. So one of the things I just talked about was that the person that I met with the hood on, that required 7 or 8 meetings that were about an hour plus each time. And for some people who are involved in busy trial practices, they may not have that time to dedicate to developing the relationship with people. I had another case where I was involved in the prosecution, and a woman wanted to review her statement. Her statement was about 2 hours, and she couldn't sit through more than 10 or 15 minutes at a time. And so we would go back for once a week, and we met probably once a week for 3 hours for about 3 months, just to get through her statement and to chat and to make her feel comfortable with the process and to answer questions and to get her prepared for court. But not everybody has that time. And so one of the things that we have incorporated into our practice in the enhanced prosecution model is to ensure we have as much time as we need to spend with people who are engaged in the court process to develop those relationships. Funding and resources is a very difficult one, and this connects to the logistics. So oftentimes we have people who are coming from out of town to testify. We need to turn our minds to issues like hotels to make sure we're not putting them up in hotels where they may have been trafficked out of. We have people who may not have funds to pay for food, breakfast, lunch, and dinner when they're testifying. They may not have clothes that they feel comfortable coming to court wearing. We take lots of breaks in court. Some people like to smoke. People may not have money for cigarettes. At the end of the day, they may not have money for housing, and we all leave court, and where is this person going? So to be able to address that in a meaningful way and meeting those basic necessity needs as well. Court can be a pretty grueling process, and we want to make sure that everybody is supported and has their needs met from the very beginning all the way to the end of the process. That requires funding, it requires resources, and it requires collaboration, because there are certain limitations on what each organization can provide for people for a whole host of different reasons. And then there are security concerns. And this is a very meaningful and important concern, because it not only affects people who are testifying, but it affects people who are coming to support the person who's testifying. And so this often requires a lot of collaboration with the police officers and with the courthouse to make sure that security concerns are addressed in a meaningful way. It can also, it also requires communication with service providers before we get to court in terms of, are there concerns about having, for instance, people who are support people, having their name on the record, canvassing that issue in advance with the police to ensure that there aren't security issues with respect to that, and if there are, figuring out meaningful ways of dealing with it. So that takes us to the second portion of the presentation, which is how do we as specialized prosecutors help to address these barriers? So in terms of education, we attempt to do our best to provide education to prosecutors, law enforcement, and the judiciary. What that looks like is oftentimes in cases, I have submissions that start out with about an hour kind of overview of the provisions, what's required, what the law says, and then we take a step back and we say, okay, so now we've heard the evidence, this is how the evidence applies to the law. And it can go all the way from that to presentations like this, presenting at judges' conferences, presenting. We have Crown schools that we've developed where we train Crown prosecutors over the course of 4 or 5 days in terms of what's required. And when there are cases that are decided, you know, that may not be in line with some of the current case law surrounding the provisions of human trafficking, then there are also appeals sought, and there's legal certainty created by having cases decided by higher courts, like the Superior Court and the Ontario Court of Appeal. We also, in terms of educating law enforcement, are involved in the human trafficking courses and the development of human trafficking courses for law enforcement. And we then attempt to continue that education by providing consistent advice to law enforcement. So when we're providing advice, the advice is consistent with the teaching that we're doing, and we're hoping that, you know, as we provide that advice and we're explaining the advice and the basis for that advice, we're also continuing to educate people about what is required to make out human trafficking. We also compile legal resources and make them easily accessible to other people involved in the criminal justice system. So this can be something as straightforward as a model charge to the jury, or a sample line of questioning in terms of how do you ask questions that paint the picture of what exploitation looks like. It can be documents like a draft information or a charging document in terms of what's required for the wording for a charge to be made out in court. And we make those resources easily accessible for people so that hopefully people aren't in the situation that I was in, which is spending hours and hours trying to figure out, what do I have to prove here? So we have a compilation of resources that are hopefully easily digestible for people and easily accessible so that they have resources at their fingertips. We also engage in the development of case law, obviously. So by prosecuting cases and by taking on cases that might be not necessarily how we kind of think of human trafficking, we are developing case law to ensure that we are starting to really kind of clearly define what human trafficking is. And the last thing that we are engaged in is developing potential expert witnesses. This is really important because we obviously want to have people who can come to court who can explain some of those difficulties and explain and articulate kind of, you know, to address the attitudinal issues. What does trauma look like? How does that impact memory? How does that impact on exploitation and the development of an exploitative relationship? How does that, you know, how can the trauma bond exist so long after a person has been exploited? Why might a person still be in love with someone even though they recognize they've been exploited? And so all of those things are very difficult for people to understand, but when you have expert witnesses who can frame that in a scientific or a psychosocial perspective, it may make it easier to address some of those issues. And to debunk some of the myths that we've been talking about. We also really strenuously and um, uh, vigorously stress the importance of knowing the world you're prosecuting. So just kind of as a silly example, the last thing in the world that you want to have to ask a survivor of human trafficking is, so tell me how you were exploited. Because someone's going to look at you and they're going to be like, what? I don't understand what you're asking me. By knowing the world you're prosecuting, you understand the types of questions to ask. And you are able to effectively and efficiently paint the picture of what exploitation looks like, going back to what we had talked about earlier in terms of painting that objective picture of exploitation, looking at all of the circumstances. So if, for example, you are prosecuting a case that involves commercial sexual exploitation out of hotels, you know the importance of, you know the intricacies of how that world works, and you know the questions to ask. Things like, who was booking the hotel? Who was paying for the hotel? How were they paying for the hotel? Who was creating the ads? Who decided the name? Who took the photos? Who wrote the words? And then using words that are key or that are known to people who are involved in that world, like were there rates for specials? Were there restrictions? And you provide explanations in your questions to the judge or the jury so they understand what you're asking about. But you also are connecting with your witness by saying to them, I understand the world you're coming from. I'm asking you to paint this picture in small, easily digestible questions that when we then take a step back and look at all of the answers, paint a very meaningful picture. And so you're asking that question of tell me how you were exploited without having to ask that question. And you really can only do that in a meaningful way if you know the world that you're prosecuting. You also have to understand the importance of asking in a non-judgmental way, and that when you indicate to your witness that you understand the world they're coming from in a non-judgmental way, it makes it much more comfortable for them to answer the questions. Going along with that, and this is very important, and this is something that we very, very, very vigorously stress again, is the importance of word choice in language, and to use language to refer to people how they refer to themselves. So it can be very demeaning in the context of commercial sexual exploitation, again, to be referred to as a prostitute for some people. Some people don't like to be referred to as sex trade workers. Some people refer to themselves as escorts. And so to understand, one, the person that you're working with, and two, the world that you're prosecuting helps you to kind of get to a place where you are not putting your witness in a place of being defensive because you're using inappropriate words that are offensive and demeaning and judgmental. Being trauma-informed and incorporating these practices into your prosecution model is something that we work very hard to teach our crowns who are designated crowns and who are practicing the enhanced prosecution model. So we teach them about the importance of trauma-informed interviewing, of building a relationship with people, being reliable, having clear boundaries, being truthful, not being misleading, and being aware again of the effects of trauma and what that looks like and how to deal with it, and taking steps to alleviate whatever stresses we can to make sure that people feel as safe as they can when they're testifying. Part of being trauma-informed is also being aware of vicarious trauma and the need to support colleagues who do this kind of work. This work is not easy. It is very, very difficult, and working with survivors of human trafficking can be very, very emotional and can be very rewarding, but it can be very difficult. And so to be cognizant of that and to be supportive to people and to make sure that they have connections to resources that they need to be able to be healthy in prosecuting these cases is really an important part of our model as well. Lastly, having a trial practice that allows for time to meet with people, as we talked about, as frequently as they wish. And sometimes that means twice before a preliminary hearing and twice before a trial, or sometimes that means once a week for 3 months. Allowing people to have a say in that, I think, is very empowering. And having the time to be able to dedicate to that goes a long way in developing that relationship with people who you're asking to come to court to testify. Knowing your resources is very important, because going back to all of those things we talked about in terms of some of the unique complexities of dealing with survivors of human trafficking, being able to connect people to resources is hugely important. Oftentimes people are moving from place to place during the course of the trial process, and being able to connect people to resources in communities, being able to connect people to resources for immediate needs, for more complex psychosocial needs, to really ensure that people who are involved in the prosecution are being supported as much as they want to be and as much as they need to be, is hugely important in being able to prosecute these cases successfully. Also, going along with that is problem solving in advance of trial. So things like knowing your case and making sure you're not booking the hotel for your witness when they've been trafficked out of that hotel. Knowing that their trafficker only fed them one type of fast food, and making sure that you're not going to feed them that type of fast food during the trial. Making sure in advance that if they need money for things like breakfast, lunch, and dinner, they don't feel like they have to ask for it on the day of, or you're in a situation where you're like, okay, everybody's going for lunch, and they're sitting there looking at you like, what do I do for lunch? Also, addressing things like testimonial aids. So if a person wants to have the use of a support dog, like Iggy, or CCTV, or if they want to testify via video link because they're outside of the jurisdiction. These are all things that need to be dealt with in advance, because it alleviates stress on people from coming to court and having to deal with these issues. It alleviates lots of the sitting around and waiting that can be really stressful for people when they're testifying. And it really allows people to just focus on the task at hand, which is coming to court to tell the truth about what happened to them. And key to that is obviously liaising with all of the stakeholders that are involved in supporting the survivor of human trafficking early and often. I can't tell you how many times a day I speak to officers and support people about cases, because there are always issues that are coming up. And that communication is key to having prosecutions that are successful, because you're making sure that all of these hiccups along the way are dealt with, and we don't end up with a big, huge problem the day of trial or the day of the preliminary hearing. So that liaising and communicating and collaborating is hugely important. And to that end, building institutional bridges is hugely important. You can't prosecute these cases alone. You can't investigate these cases alone, and survivors cannot be supported meaningfully alone. So it's only through building bridges and through collaborating and communicating that we can meaningfully prosecute these offenses. And with that, I will put our last slide on, which is the contact information for our team. We're always available to build institutional bridges, to answer questions, to provide education, to do all of the things that we talked about as part of the enhanced prosecution model. And we are very open to having people contact us for any kinds of questions or information. So I think we can open it up for questions if there are any at this point. So there's one question: how often does a person charged with human trafficking receive a life sentence? I don't think I've seen it in Canada yet. Generally, the range for a first offender, a person who's convicted for the first time, if the victim is over the age of 18, is somewhere in the range of 4 to 6 years, depending on the facts. The highest sentence in Ontario that's been given out so far is 14 years. That was a person who was trafficked for 4 years with very extreme violence. And for offenses that are for victims under the age of 18, we're looking generally at the range of 6 to 8 years for one victim for a first offender. Oh, you mentioned funds for lunches, other expenses. This is a hard one. So the question is, you mentioned fund for lunches, other expenses for victims. Is this a Crown fund? No, it is not. So generally, there are, oh, someone has a question after. Generally, there are per diems available. The problem with per diems is that the person has to put the money forward and then they get reimbursed. There is a fund that's being developed to address this so that we can provide the money up front for the per diem. But Other ways that we have dealt with this issue is that support organizations have provided gift cards or like prepaid cards for certain hotels, or we've authorized if a person is staying at a hotel that they can charge the per diem to their room. So we have tried to address it, but there's not a specific Crown fund that pays for meals. Yeah, so the person who asked the question about the cards just said they operate similarly, but they like the idea of donations of gift cards. And that's been something that's been hugely meaningful, because it's very difficult otherwise to have the money up front for people who don't have the amount to support themselves for the per diem. So and that's one of the things in terms of building those relationships, those institutional bridges, is developing relationships with people and organizations who have that ability to provide those gift cards. But it's a really difficult issue for sure. Are there differences? Oh, sorry. How do you anticipate the decision from the court in Ontario that persons can expect a reasonable expectation over privacy over virtual communications will affect human trafficking cases where the victims are in the webcam industry? Are there differences between organized trafficking? Oh, sorry. Those are two different questions. So the question in terms of reasonable expectation of privacy, oh, I have 1 minute, sorry. And webcam is, the question really is there going to be a basis for people to argue that they do have a reasonable expectation of privacy? And I think in the webcam industry, it may be difficult to articulate that you have a reasonable expectation of privacy if it's being broadcast. Where we do encounter this issue is downloading phones. And if a person is not the exclusive user of the phone, then we get into issues relating to Section 8. And so we have trained law enforcement to ask questions to make sure that when they are obtaining consents, they are obtaining the consent of the exclusive user of the phone. And I think we have to cut it off here. If anybody has any other questions they'd like me to ask, or they'd like to ask me, feel free to email me anytime. My contact information is on the slide. Thank you.